Welcome to the deep dive. Today, we are opening up a stack of documents that detail not just an error, but something much deeper.
It's a profound and structural failure, and it's happening within law enforcement in the state of Tennessee.
Right. Our sources, and we're talking about investigative reports, court filings, official state data, they all reveal a systemic crisis.
And that crisis is that hundreds of people are being arrested for driving under the influence, despite being completely objectively sober.
It's an extraordinary finding.
It is, and I think the most critical element of this deep dive is that the extent of this injustice is now verified. It's verified by the Tennessee Bureau of Investigation's own toxicology reports.
So this isn't speculation, this is their data.
Exactly. So our mission today is to go far beyond that headline number. We need to unpack the specifics, the sheer scale of the problem.
Which is over 400 wrongful arrests in just 1 year.
In a single year. And then we need to look at the catastrophic human and financial cost, and most importantly, the specific systemic flaws. We're talking about incentives, training deficiencies.
All the things that prioritize making an arrest over, upholding accuracy and constitutional rights.
Oh, that's the core tension right there. That's what we're exploring. The mandate to protect public safety versus the fundamental right of a citizen to be secure from an unlawful seizure.
Okay, so before we get into that massive data set, let's anchor ourselves. Let's start with a story that really puts a human face on this systemic failure.
Yes.
We have to start with the specific pre-data case of a man named David Dutton. Now, this happened in 2024, and it's so critical because it illustrates the exact pattern that the state's 2025 data would later confirm was happening everywhere.
Dutton's case is it's a crucial warning sign. He's a 76-year-old resident of Rutherford County.
Okay.
And according to his account, and what later unfolded in court, he was pulled over one night in 2024.
And he was.
He was sober, he was cooperative, respectful, and by all accounts, was not driving erratically at all. There was no visible sign of the kind of impairment that should establish probable cause for a stop, let alone a DUI arrest.
And yet, he was stopped. He was subjected to field sobriety tests, FSTs, and he was ultimately arrested and charged with DUI.
And we know, based on the toxicology that came back later, that he was 100% sober.
His experience was so egregious that it led to a significant federal civil rights lawsuit against the Rutherford County Sheriff's Office and the deputies involved.
Which tells you something right there. This wasn't just about fighting a misdemeanor charge.
No, this was about fundamental constitutional protections.
And if you really dissect the allegations in his federal complaint, you see the exact roadmap of these systemic failures.
What does it say?
Dutton's suit argues, first, that there was no probable cause to even initiate the traffic stop. Right there, that's a violation of his Fourth Amendment rights against unreasonable searches and seizures.
Okay, so the stop itself was illegal.
That's the argument. But beyond that, the suit contends that the field sobriety tests, those exercises officers use to assess impairment.
Right, the walk the line, touch your nose.
Exactly, that they were either improperly administered, misinterpreted, or maybe both by officers who are already, sort of predisposed to making an arrest.
Let's just dwell on that for a moment. The claim is they violated his constitutional rights, and that resulted in emotional distress, reputational damage,
and significant financial consequences.
The fact that this specific set of allegations, no probable cause, flawed testing, constitutional harm, that this was all laid out in a federal court filing before the statewide data came out.
That's the key.
It really establishes that this pattern was pervasive, it was systematic, and it was well known to the victims, even if the state wasn't tracking it yet.
What's truly fascinating is that time disconnect. The systemic failure, the rush to judgment, the flawed training, the pressure to arrest, that was all operating in 2024. We see it with Dutton's experience.
But the official data, the proof, wasn't public.
Right. The official accountability mechanism, the TBI toxicology data that proved the arrests were bad, that wasn't being publicly tracked or released until the next year. And that was largely due to investigative reporting.
So Dutton's case really stands as this localized, painful example that foreshadowed the precise systemic pattern that the state's data would soon be forced to confirm on a massive scale.
Exactly. A warning sign that no one heeded until the data became undeniable.
And now let's jump into that massive scale. This is where the story shifts from a single compelling anecdote to verifiable, overwhelming statewide crisis data.
This is where we talk about the new mandatory data released by the Tennessee Bureau of Investigation in 2025.
And this is the definitive finding that changed everything.
It absolutely did. It took the narrative of, a few bad apples and just replaced it with evidence of a verified systemic collapse.
So what's the key statistic?
The key statistic is astonishing. In the calendar year 2025 alone, 419 Tennesseans were arrested for DUI, where subsequent toxicology analysis detected no alcohol and no basic drugs.
419 people. When we say no alcohol and no basic drugs, we need to be really clear about what the TBI testing is actually designed to do.
Right.
These toxicology reports are comprehensive. They're not just testing for, simple alcohol content. They're analyzing blood or urine for a broad spectrum of common illicit substances, prescription drugs known to cause impairment.
And certainly basic alcohol metabolites.
Yeah.
So for 419 arrests to come back completely clean, not just below the legal limit, but showing nothing.
It means the officers had absolutely no objective basis for the arrests.
Precisely. These are not technicalities. These are not borderline cases.
No.
These are 419 people who were booked, processed, fingerprinted,
Yeah.
had their constitutional rights violated, and were forced to defend themselves against serious criminal charges while being fundamentally sober.
The implications for the state's justice system are just chilling.
And this represents the highest number of such wrongful arrests ever recorded.
And if you look at the geography of this crisis, the problem isn't just isolated to one city, is it?
Not at all. The data confirms the failure spans the entire state. It involves dozens of different agencies, which suggests a deeply entrenched cultural problem, not just a localized training issue.
But while it spans the state, there is a distinct point of concentration that demands attention.
There is. If we look at responsibility across agencies, the Tennessee Highway Patrol, the THP.
The flagship state law enforcement body.
Exactly.
Yeah.
The agency responsible for highway safety. They account for nearly half of all these wrongful arrests.
Half.
Nearly half.
So we're talking about approximately 180 innocent people arrested by the Tennessee Highway Patrol in 1 year alone.
That's right. 180.
When the agency that's supposed to be setting the standard for statewide road safety is responsible for such a disproportionate share of wrongful arrests, you can't dismiss that as coincidence.
No, you can't. It suggests that the core training, the supervisory culture, and the operational incentives within the THP are the central drivers of this entire systemic failure.
It just raises the question, what exactly is the THP prioritizing?
Well, if not the accurate determination of impairment, then what? If nearly 180 of their arrests are overturned by the state's own forensic scientists, then the metric for success for that agency has to be volume of arrests, not quality of evidence.
Let's ground this again. Let's zoom back into that familiar location, Rutherford County.
Where David Dutton was arrested in 2024.
Right. If we look at the 2025 data, we see an alarming concentration there that just reinforces this idea of a pervasive local failure.
Rutherford County, in 1 year, saw 27 completely innocent individuals arrested for DUI.
27.
When you consider the population size and the number of jurisdictions involved, that concentration is startling. This isn't just a state-level issue. The local agencies are deeply implicated as well.
And the sources give us the exact breakdown, which really paints a picture of just organizational failure within that county.
What are the numbers?
The Laverne Police Department, they accounted for 11 wrongful arrests. The Murfreesboro Police Department followed with 7. The Rutherford County Sheriff's Office, the same agency facing Dutton's federal lawsuit, accounted for 6 more.
So they just kept doing it.
I seem so. Then Smyrna PD had 2, and even the Middle Tennessee State University Police Department, the MTSU PD, had 1.
That density, 27 lives upended across 5 distinct agencies within the borders of one relatively small county. It strongly suggests that whatever deficiency is driving this problem,
Whether it's pressure, training, lack of scrutiny.
it's shared. It's a common problem. If that is the density in Rutherford County, you have to then extrapolate that out. Imagine the full picture across all 95 counties in Tennessee.
That 419 statewide total, it starts to feel less like a shocking ceiling and more like a terrifying floor.
Exactly.
That density of error in Rutherford County is startling, and it leads us inevitably to the question. If the TBI knows these arrests were bad, what is actually broken inside the system that allows this to happen 419 times?
Right.
Let's dissect the mechanics of this collapse.
This is where we get into the internal processes. And our sources point to 4 Really undeniable systematic themes that explain how accuracy gets sacrificed in the field.
Okay, what's the first one?
The first, and perhaps the most corrosive, is the culture of pressure and quotas.
When law enforcement agencies measure success primarily, or even solely, by the quantity of arrests made just the raw numbers.
They're subtly, or in some cases overtly, shifting the mission away from justice and accuracy.
The investigative reporting highlighted how, in this scenario, accuracy just becomes collateral damage.
And look, this isn't just about officers feeling some sort of generalized pressure. The sources cite explicit recorded evidence of this culture within the THP.
There was a specific incident, right?
A very specific incident. A THP captain was recorded telling his troopers directly, in no uncertain terms, arrest every DUI you can get your hands on.
Arrest every DUI you can get your hands on.
That quote is absolutely crucial. It establishes a clear top-down incentive structure. It transforms the professional mandate to establish probable cause based on objective facts into a simple command for volume.
So if your captain tells you to do that, regardless of the quality of the evidence, what is the fastest way to get to that number?
Well, it's not careful observation.
No. It's rushing the assessment, interpreting any ambiguity as guilt, and prioritizing a subjective feeling over scientific fact.
It essentially creates an organizational bias towards finding impairment, even when none exists.
And when you have that kind of explicit pressure, the second theme training, it starts to look inadequate by design.
Of course. You can't afford time for meticulous, high-quality training if the immediate goal is just to put troopers on the road to meet quotas.
And the internal communications within the THP, which were revealed in 2025, they confirmed that the agency was keenly aware of its own deficiencies.
Oh, they knew. Supervisors were conducting internal audits specifically of those double negative.
Which is their term for arrests later cleared by toxicology.
Right. They knew the problem was systemic and rooted in their initial processes.
So what were they doing about it?
The need for corrective action was constant. They were repeatedly scheduling mandatory DUI refresher trainings.
Which is a sign in itself.
It's a huge sign. If you need constant, urgent refresher trainings, it is a clear organizational acknowledgement that the foundational training received at the academy was insufficient to begin with.
And the supervisors admitted as much.
They did. They admitted in those emails that the academy training might have been rushed.
Let's think about what rushed really means in the context of DUI enforcement. It means insufficient time dedicated to the complex legal standards for probable cause.
And crucially, insufficient time practicing the standardized field sobriety tests, the very mechanism used to determine impairment on the roadside.
A rushed academy training compromises the most critical tool an officer has.
It does. The FSTs, while they're used universally, are only validated by the National Highway Traffic Safety Administration, NHTSA, if they are administered strictly according to protocol.
Any deviation.
Any deviation, failing to give clear instructions, a poor demonstration, having the driver perform the test on uneven ground, it renders the test results unreliable. Rush training means officers just don't master the strict adherence they need.
And that leads us directly into Theme 3, the over-reliance on subjective impressions instead of objective evidence.
That's a natural consequence.
We've established the training is shaky and the pressure to arrest is high. So when an officer is looking for impairment, they're going to rely on these vague observations that are highly susceptible to observer bias.
This is a critical point for civil liberties. The sources detail the types of non-specific subjective observations officers relied on to make those 419 bad arrests.
What kind of things are we talking about?
We see claims about bouncing or jerky eyes, which is often a reference to the horizontal gaze nystagmus test.
Right.
And then generalized statements, which are totally meaningless in court, like you can see it in their eyes or slow responses.
Let's just unpack the FSTs a bit more because this is where the technical failure happens. The FST battery has 3 main tests, right?
That's right. The horizontal gaze nystagmus, or HGN, the walk and turn, and the one-leg stand.
So the HGN measures that involuntary jerking of the eye.
Correct. Officers are trained to look for specific cues, like a lack of smooth pursuit or distinct nystagmus at maximum deviation. But here's the rub.
What's that?
Nystagmus can be caused by countless factors other than alcohol. Certain medications, inner ear issues, even simple fatigue.
So if an officer is operating under pressure to find a DUI,
they are far more likely to interpret a pre-existing medical condition or even just the nervousness of being pulled over as a sign of impairment.
Then you have the physical tests, like the walk and turn.
The standard protocol requires the subject to take 9 heel-to-toe steps, turn in a specific manner, and take 9 steps back. Officers look for cues like starting too soon, stopping, not touching heel to toe, stepping off the line.
And the one-leg stand.
That requires the driver to balance for 30 seconds while counting. The cues are swaying, using arms to balance, hopping, or putting the foot down.
But these tests require good balance, coordination, attention, all things that can be compromised by age, weight, medical conditions, even just the shoes you're wearing.
Exactly. And if the officer has rush training, they're less likely to adhere strictly to the standardized procedures. Maybe they didn't properly instruct the driver, or maybe they let them perform the test on a non-level surface.
And if they're under pressure, they are highly likely to mark minor deviations, like stepping slightly off the line, as cues of impairment that justify the arrest.
And here is the truly alarming data point that just underlines the objective failure here.
What's that?
The alarming absence of objective confirmation. The investigative sources confirm that in many of these 419 wrongful arrests, breathalyzers were often not used,
Even when they had them.
even when they were available in the officer's vehicle.
Why refuse the objective evidence? A breathalyzer gives you an instantaneous, legally sound measurement of blood alcohol content.
It does.
If an officer has the tool to quickly and definitively rule out the most common form of impairment alcohol, and they choose instead to proceed based purely on subjective, vague observations of bouncing eyes and a shaky balance test,
They are actively prioritizing the impression of guilt over the fact of innocence.
it paints a perfect operational picture. High pressure to arrest, inadequate training, a cultural reliance on subjective observations.
Coupled with a purposeful disregard for available objective evidence. It is a system designed to generate flawed arrests.
But the injustice doesn't stop when the handcuffs are applied. The story continues, and it gets worse once toxicology proves the driver was innocent.
That's right.
And that leads us to theme 4, a system designed for citizen penalty. There's a complete lack of accountability after the lab proves innocence.
We've violated the citizens' constitutional rights, put them through a traumatic arrest, and then the state's own lab proves it was all a mistake. What happens next?
The sources detail a grim post-exoneration reality. The arrest, the mugshot, the initial booking information, the public record of the alleged crime. It remains on the individual's record.
This causes permanent digital harm. Mugshots, the immediate universal symbol of criminal guilt, remain published online, often scraped by third-party websites and retained in search engine indexes forever.
And what about the law enforcement structure?
The system is designed to absorb the mistake without consequences. Officers involved in wrongful arrests face no transparent consequences, no public reprimands, no clear disciplinary action that can be tracked.
Do the agencies ever admit fault?
They rarely, if ever, acknowledge the error, apologize publicly, or take proactive steps to clear the name of the innocent driver they victimized.
So this is the core structural imbalance.
It is. The system is structured so that the innocent citizen has to absorb the emotional, the financial, and the reputational price of the state's negligence. The law enforcement agency or the individual officers who violated the Fourth Amendment are insulated from any meaningful, publicly visible accountability.
The cost of the error is externalized onto the victim.
Every single time.
That externalization of cost is devastating, and it takes us perfectly into the next section. The human and financial cost. The damage that doesn't get counted by the state.
Right.
When we look at the immediate financial ruin, the scope of the injury comes into sharp focus.
The financial shockwave is immediate, it's devastating, and it's entirely unexpected. We can use the case of Stephen Smart, a man in Knoxville, as a perfect illustration.
He was one of the wrongfully arrested in 2025.
Yes. Like the 419 others, his blood test later confirmed he was completely clear. No alcohol, no drugs.
But the arrest itself set off a catastrophic chain reaction. Smart wasn't just cleared, he had to fight for that clearance.
And here's where the detail matters. Stephen Smart spent $10,500 defending himself against a crime the state manufactured.
$10,500. Let's break that down.
A standard DUI defense, even for an innocent person, requires an immediate outlay of funds. First, there's the lawyer's retainer fee, which for a serious criminal defense case like a DUI can easily range from $5,000 to $7,000 just to get started.
And that just covers initial motions and appearances.
Exactly. Then you have the costs associated with discovery. The lawyer needs to formally demand and receive all the evidence. Dashcam footage, body camera footage, police reports, and crucially, the TBI toxicology report. The processing of all that adds significantly to the bill.
And I imagine in cases like this where the defense hinges on proving the FSTs were flawed.
The defense attorney often has to hire an expert witness. a toxicologist, or a former law enforcement trainer to review the procedures and testify that the officer misadministered the test or misinterpreted the results.
And expert testimony is incredibly costly.
Easily adds thousands more to the tab.
So that $10,500 wasn't optional. It was the cost of proving his innocence.
And the sources confirm he didn't have that cash just lying around. He drained his savings and was forced to incur significant credit card debt just to protect his freedom and clear his name.
And beyond the raw dollars, you have to consider the psychological and social costs of that financial devastation.
Smart lost friendships and stability. An arrest, even a wrongful one that is eventually cleared, creates a social stigma and forces individuals to sacrifice their economic foundation simply to navigate the justice system.
For many citizens, $10,500 is a life-altering amount that cannot be recovered easily, if ever.
And that financial shock only deepens when you account for the long-term, non-monetary costs, the reputational damage.
The permanent digital stigma that adheres to a person long after a court dismisses the charges.
We're operating in a world where initial arrest records and mugshots are published online almost instantaneously. They are indexed by major search engines and scooped up by all these arrest record websites.
That digital scar is permanent.
It is.
Think about the professional and personal consequences. When someone applies for a job, particularly one that requires driving or bonding, or when they apply to rent a new apartment,
The first thing a landlord or an HR manager does is run a background check. And that background check is often populated by those initial damning arrest records.
and the cruel irony is so profound, even when the toxicology report confirms you were sober and the charges are dropped.
The digital record of the arrest persists indefinitely. The record of the exoneration is rarely tracked or publicized with the same speed or efficiency.
And that reputational damage translates directly into lost employment opportunities, housing barriers, often higher insurance rates, even if you were never convicted.
That stigma forces the innocent citizen to continue paying. They have to disclose the arrest on applications, they have to spend hours explaining the mistake to employers, and critically, they often have to pay thousands more in legal fees just to get the charge expunged.
And we have to emphasize that expungement is not automatic.
Not at all. The sources indicate that even in cases of complete innocence, the process is often complicated, requires separate legal fees, involves waiting periods, and depends on court scheduling.
It places the entire bureaucratic burden back onto the victim, extending the punishment long after their innocence has been proven.
And because of this profound and ongoing financial and reputational harm, many of these victims have turned to the courts.
Which has resulted in a flurry of federal civil rights lawsuits and confirmed settlements. This is the legal fallout that confirms the state has been forced to acknowledge some level of liability for these constitutional violations.
We can look at the ongoing litigation for the David Dutton case in Rutherford County. That's a massive federal civil rights lawsuit alleging unlawful arrest and constitutional violations. These are expensive, drawn-out affairs that require significant taxpayer resources to defend.
But we also have confirmed financial settlements that show the immediate cost to the taxpayer.
Right. FOX 17, through their investigative work, confirmed that a sober driver who was wrongfully arrested in Goodlettsville received a confirmed settlement of several $1,000s from the city.
That's a clear indicator that when the state is forced to defend these indefensible arrests in court, they often choose to pay out to avoid the greater cost of losing a civil rights trial.
And the sources reference multiple other civil rights lawsuits documented against THP troopers and local departments across the state, many of them detailed in WSMV's extensive investigative series, Sobering Problem.
These are the tangible, legally recognized costs of systemic failure.
Yes, but this brings us to the hidden cost.
The tip of the iceberg.
For every successful public settlement, like the one in Goodlettsville, or for every high-profile federal lawsuit, there are countless other victims who, like Stephen Smart, simply absorb the financial devastation silently.
They can't afford the $10,000 retainer to sue the government agency.
Or they lack the financial stability to sustain a multi-year legal battle. They are the ones who pay the thousands of dollars in legal fees to their initial defense attorney, struggle with the digital stigma, and endure the emotional and professional damage alone.
So the true scale of the financial damage inflicted upon Tennessee's citizenry is exponentially higher than the public settlements reveal.
Much higher.
And that takes us perfectly into our final section: policy failure and the untracked harm. This is where the system's complicity in this ongoing crisis becomes most visible.
We need to clearly contrast the costs that are known, the few settlements, versus the private costs that are completely unknown to the public ledger.
On the known side, we have the direct public costs, settlement payouts, and the future payouts that are inevitable from pending lawsuits like Dunn's.
This is taxpayer money being used to retroactively apologize for the state's failure.
But these known public costs are absolutely dwarfed by the private costs borne by the innocent drivers.
We're talking legal fees from $5,000 to over $15,000, lost wages from missed work and court dates, the accumulation of high-interest credit card debt used to pay for it all.
And the long-term in-prim loss due to the reputational damage we've discussed. The state of Tennessee is essentially forcing its citizens into deep personal debt to fix the state's own constitutional errors.
And this is the core policy failure. The state tracks the number of innocent people arrested, the 418 in 2025, but they fundamentally fail to track the harm caused by the state's negligence.
This failure to measure the negative consequence is the mechanism that prevents real structural change.
They are choosing not to track the most crucial metrics that would force accountability.
We have to list them out. The uncounted costs are essential to understanding the scope of this negligence.
Okay, so taxpayer settlement amounts over time are often hard to aggregate. The total amount of money lost by victims through legal fees and debt is untracked. The number of careers damaged by the stigma, the number of families destabilized by the financial shock.
And critically, the percentage of people who never financially or professionally recovered from the ordeal. All these essential metrics of harm are simply ignored.
By tracking the arrests, but not tracking the harm, the state effectively ensures there is no fiscal pressure to correct the underlying behavioral problems.
If law enforcement agencies are not forced to confront the true financial devastation caused by the errors of their officers, if the costs are absorbed by the victim or the general taxpayer through these invisible settlements.
The internal incentive to prioritize high-volume arrests over accurate policing remains dominant.
And we have to stress the element of reactive governance here.
Absolutely.
The state only began counting these sober DUI arrests, that official 419 figure, because lawmakers were ultimately forced to act following extensive investigative reporting that exposed the gravity of the problem.
This was not a proactive protection of citizens' constitutional rights. It was a reluctant, reactive response to public outcry and documented journalism.
That reactive stance confirms the deep-seated structural nature of the failure.
The very fact that the TBI data had to be created proves that, until they were forced, the state preferred not to know the extent of the harm.
And even after the data revealed the problem, the core elements of the failure persisted.
Incentives prioritizing arrests over accuracy, acknowledged internal training gaps that went uncorrected, a failure to automatically clear the records of exonerated individuals, and a complete lack of transparent accountability for the officers involved.
And here is perhaps the most damning indictment of the structural failure. The statewide pattern of harm, the continued arresting of innocent citizens, persisted well into 2026.
That's the key. This means that even after the 2025 data was published, after the investigative reports aired, and after the problem was acknowledged in the press, the internal culture and policy deficiencies within agencies like the THP were not immediately corrected.
The incentive structure was so strong that the wrongful arrests continued at a high rate.
This is why we call this a systemic failure, not a series of individual mistakes. When hundreds of innocent people are arrested in a single year, and the problem continues even after that failure is quantified by the state's own forensic data.
It reveals a system where the costs of the error are borne entirely by the victim and the taxpayer.
While at the rewards, high arrest numbers are retained by the agencies, this is a fundamental challenge to public trust and due process.
Okay, let's summarize the findings of this incredibly deep dive, emphasizing the staggering magnitude of this crisis. We have confirmed 419 completely innocent lives upended in 1 year alone.
We have documented widespread agency involvement, with the Tennessee Highway Patrol responsible for nearly half of those unlawful seizures.
The human fallout is catastrophic and quantifiable. Innocent citizens draining their savings, accumulating thousands in credit card debt, facing devastating reputational harm from a permanent digital stigma.
And mounting civil rights lawsuits that confirm the state's legal liability and cost taxpayers significantly through settlement payouts.
And all of this occurs because of documented systemic drivers. A high-pressure, quota-driven culture, rushed training that compromises officer competence,
And a failure to use available objective technology like breathalyzers in favor of vague subjective observations.
The inescapable truth, now that the TBI's own forensic numbers are public, is that Tennessee law enforcement can no longer claim ignorance of this structural failure.
No, they can't.
Sorry.
This is not just a policy issue. It is a critical civil rights issue where the operational incentives of law enforcement are demonstrably misaligned with the constitutional protections they are sworn to uphold.
As we conclude this deep dive, we want to pose a provocative thought for you, the listener, building on the critical policy failure we have identified, that failure to track the harm.
Right.
Since the state already tracks the number of wrongful arrests, the 419 figure, and since true accountability requires fiscal consequences, what practical legislation or policy change must citizens or communities demand to ensure law enforcement incentives align with accuracy and constitutional rights?
It's a great question.
Specifically, should state policy mandate that the TBI or the relevant oversight body also track the financial cost associated with every single cleared case, the expungement costs, the known legal fees incurred by victims, and the full taxpayer settlement amounts, to force visible, unavoidable fiscal accountability onto the agencies responsible for the error?
This is the only way to ensure the police absorb the cost of their errors rather
Yeah.
than passing that devastation on to the innocent people they arrest.